Thank you all for coming. My name is Brittany. I'm the Vice President of the Human Rights Law Society. We want to thank the Immigration Law Society, the Law Women's Caucus, and the Domestic Violence Project for co-sponsoring this great event today. Today we have Professor Caroline Beninger-Lopez. She's a visiting Associate Clinical Professor and also the Acting Director of the International Human Rights Clinic. Professor Beninger-Lopez was the lead counsel on the first international human rights case that was brought by a domestic violence victim against the United States. This landmark case was before the Inter-American Commission on Human Rights and proclaimed human rights to be free from domestic violence. She's also going to be speaking on new precedent, which finds immigrant women eligible for asylum in the United States on the basis of domestic abuse. So without further ado, Professor Beninger-Lopez.
Thank you so much, and thanks to all of the organizations for having me, and it's just such a pleasure to be here. It's a great turnout, and I'm just really enjoying being here at University of Chicago this fall. As many of you know, some of you are my students, and I'm directing the International Human Rights Clinic here, along with Brian Citro, and then also teaching a seminar on international human rights law and advocacy. So my first caveat to my presentation is my apologies that my voice is kind of giving out. I hope it won't give out like it did yesterday in class, where my students know I actually had to walk out of class. So hopefully you can everybody hear me okay? I'm not projecting as much as I probably normally would, but hopefully the microphone will help take care of that. And secondly, just a show of hands, how many folks are 1Ls in the room? Okay, lots of 1Ls and 2Ls. And I know probably nobody's a 3L, right? Because there's a mandatory 3L talk today. And LLMs? Great. Okay, what a nice diverse group of folks here. For the 1Ls and 2Ls, I want to just encourage you that if you're interested in some of the things that we're talking about today, I want to encourage you to think about joining a clinic, whether it's the International Human Rights Clinic or any of the other clinics that are offered here. Everything that you're going to see here are activities that clinic students have been integrally a part of. And it's only as a result of really the amazing work of clinic students over the past, 8 years on the Jessica Lenahan case that we have achieved the level of success and progress that we have. So being in a clinic is the most amazing hands-on experience that you can have in law school. And so I want to just encourage everybody to kind of think about that as I'm going through the presentation. Okay, so we have until, is it 1:30? Okay, so the way I'm going to do this is that I'm going to go through a PowerPoint presentation. I have a couple of videos to show everybody, and then I'm really interested in engaging with all of you and hearing your thoughts on this case and the campaign that it's really given rise to. So I hope that we can have a rich discussion for the second part of this lunch period. Okay. So let's start out. How many of you have heard of the Jessica Lenahan case? How many of you have heard of the case of Town of Castle Rock versus Jessica Gonzalez? Perhaps that's the same cluster. How many of you have taken con law? Okay. So for those of you who take con law kind of in the future, this case actually comes up in con law, property law, international human rights law, women in the law, family law. This is one of those cases that covers a lot of different kind of boundaries within the law. And so I want you to kind of think about where this might come up in your own legal education and how it gets presented before the U.S. courts and then before the international human rights body, which is the Inter-American Commission on Human Rights. And I want you to just think about kind of the legal frameworks that you're learning about in class and how those juxtapose with the legal frameworks that you're going to hear about today that are a part of this case. So before I get into the case, I want to show you a video because Jessica can tell her story far better than I can. So let's hope our technology works. I'm going to press play. This is about an 8-minute video, and then we'll return to the presentation.
Hi, I'm Jessica Lanahan. I'm the petitioner in the case of Jessica Gonzalez versus the United States of America. My life's work is to educate Americans that protection from domestic violence is our human right. I was born and raised in Pueblo, Colorado. I'm Native American and Latina. I met Simon Gonzalez when we were children. Through the years, we saw each other off and on and eventually got married in 1990. We had 3 daughters, Rebecca, Catherine, and Leslie Gonzalez. Slowly but surely, just became very controlling in what I wore and who I spoke to, and it slowly crept in over the 10.5 years that we had a marriage.
And he started acting really erratic, and threats of wanting to kill himself and threatening his neighbors, I'm gonna die, you're gonna die, somebody's gonna die.
He actually tried to hang himself in the garage in front of my children at one time. When you're a victim, you try to portray this life like it's fine, like there's nothing wrong. But when my children were starting to become affected and become frightened of him, I just decided that we're just gonna tell the truth. And no matter how painful or shameful I felt at that time, that it was really necessary to do whatever I needed to do as a mother to protect my children. In 1999, I decided I needed a restraining order, that it just got so dangerous for the children. I went before the judge and explained what was going on within my home, and the judge realized that Simon was a danger to me and the children, and that he needed to not be a part of the home at all and needed to stay at least 100 yards from the household itself. On June 22nd, 1999, Simon violated the restraining order by kidnapping the girls from my front yard. I called the police, and dispatch was supposed to send a car out, and I waited hours before they came out, and I called again. I'd given the officers the restraining order when they arrived, and they decided that because Simon was their father, that the children would be fine and they didn't have to look for them. I shouldn't worry because they were with their father. But all in all, they just, throughout the evening, didn't look for them at all. They were very dismissive of any requests I made and belittling to me for even asking them for help. They called me ridiculous at one point. I contacted the police 9 times altogether, twice in person and 7 times over the telephone. At 3:20 in the morning, Simon pulled up in front of the police station after buying a gun and opened fired on the police. And they fired back. Simon died, shot him dead. And then they found the bodies of my 3 children shot to death in the cab of the truck. Eventually, it went to the highest court in the land, which was the Supreme Court. The United States Supreme Court said that I had no constitutional right to police protection or enforcement of my restraining order. So if restraining orders are not enforced, then they're not worth the paper they're written on. I filed a case with the Inter-American Commission on Human Rights because my human rights were violated by Castle Rock, Colorado for not enforcing a restraining order to protect my children and myself. And my human rights were also violated within the court system for not providing a remedy.
I deserve answers, and I deserve to know the truth. I want to know why the police ignored my calls for help. I've been asking these questions for 9 years. 9 long years. How long will it take for you to help me discover the truth? I know I cannot bring my children back from that night. The emptiness I feel when I remember my daughters and the great lives they might have lived. Nothing can bring them back. Nothing. What I can do, however, is to be a voice for the voiceless and women who are promised protection in America and then denied it in the moment they're in danger.
By deciding in my favor, the Inter-American Commission has recognized that the United States allows human rights violations to continue against women and children. These are the facts and the statistics in our country. 1.3 million women are physically assaulted in the United States by an intimate partner each year. Every day, approximately 3 women and 1 man are murdered in the United States by an intimate partner. Every year, 3.3 million children are exposed to violence against their mothers or their female caretakers. Every day, approximately 4 children die from violence in the home. There are preventative measures. I believe education starting from very young will prevent violence, domestic violence, violence against women. All in all, it's not up to the Commission to change the U.S. It's up to United States citizens to decide to change this world for themselves. They can give us all the tools, but we have got to be able to embrace and put them to use. Our society traditionally thought of domestic violence as something that happened behind closed doors and that it was nobody else's business. But it is our business, and it should be our government's business too. Our government can't turn a blind eye to this human rights violation. It's happening right under their noses. Our country has an obligation to stop domestic violence in its tracks.
Okay. So it's obviously a pretty halting video. Let's hope that's just stop. It's startling and halting, and when people first learn of the story, many people, if they don't know where the story takes place, they say, what country was that in? And when I tell them the United States, people are shocked. And so what I want to go through with you is a little bit about the facts and the law behind this case from a U.S. law perspective, and then shift over to thinking about how we brought this case to the Inter-American Commission on Human Rights. So as you heard Jessica so powerfully say, when we think of domestic violence, and when we see headlines in the newspapers and such, it's often framed as the most private of violence. Domestic violence being something that oftentimes takes place in the home, behind closed doors, and we don't often think of it as a human rights violation. We think of human rights violations, first of all, as things that happen out there somewhere else in the world. And when we associate those things maybe with the United States, we associate them with kind of massive abuses of power. Perhaps Guantanamo would come to mind. People talk about the death penalty and police brutality. Those are areas that have been more the traditional focus of human rights advocacy in the United States, focused on the U.S. But the idea of domestic violence being a human rights violation has been quite underdeveloped. When we think, as Jessica says, it's happening right underneath our noses, right? When we think about the statistics that she puts forward, as the UN Special Rapporteur on Violence Against Women has said, violence against women is the most pervasive human rights violation in the world because it affects such a large number of people. And so part of the impetus behind this case is thinking about shifting from a frame of domestic violence as the most private of affairs to domestic violence as a human rights violation, a societal epidemic, a structural problem that demands government accountability. And so I just want to review the facts of the case and also just point you to this headline, right? This is the headline from the day after, and you see this idea of domestic violence as being kind of an issue that happens between partners and is not necessarily linked to a notion of governmental accountability. Man dies in shootout, daughter's found dead, family was troubled, friends say. And this is your typical newspaper headline that you see after domestic violence tragedies that blanket our media and social media every day. And so let's think about the facts of the case, right? This takes place in 1999. We have a restraining order in place, which means that Jessica has actually gone to a court and put forward a case for why she feels that she's at risk. The court has granted her a restraining order that orders Simon Gonzalez, her husband, to stay 100 feet away from the house and from Jessica and their 3 children. And he abducts the 3 daughters. She calls the police. Colorado is what's called a mandatory arrest state. How many of you have heard of mandatory arrest states, mandatory arrest laws? Okay, so mandatory arrest laws we have in about 32 states in this country. They remove police discretion from getting, when they get domestic violence calls, from making an arrest. The idea was that in the past, historically, law enforcement officers disregarded calls for help from domestic violence victims. They had many kind of stereotypes and discriminatory attitudes towards women who were calling for help and would often tell them, take a walk around the block, tell him to splash some water on his face. I'm using gendered pronouns here, not to minimize the effect of domestic violence on men and women, because men and women, of course, can be victims. But the statistics, as Jessica shows that women and girls are predominantly the victims of domestic violence, and that men are predominantly the abusers. So Colorado is this mandatory arrest state, and I'll show you the language of the law in a minute, but the idea is that the police don't have discretion about whether to make an arrest. If they have probable cause to believe that a restraining order has been violated, they must arrest, or at least they shall arrest, as you'll see in the language of the law. And so, as Jessica says, nearly 10 hours go by. At one point, she tells the police, I know where they are. They're in Denver at Elitch Gardens Amusement Park. And the Castle Rock police respond, well, that's outside of our jurisdiction. There's nothing we can do. She goes in person to the police. She has 9 points of contact with the police over a nearly 10-hour period. And her anxiety is increasing and escalating. As she says, at one point around 10 p.m., the police called her ridiculous for freaking out. After all, the police said the children are with their father, disregarding the terms of the restraining order. And at around 3 in the morning, as she said, the husband showed up at the police station, opened fire, and the police shot and killed him and found the girls dead inside the truck. And there was never actually an investigation into how, when, and where those children died. It was assumed that they died from a gun that their father purchased earlier that evening, and he fell through all the background checks that were supposed to be in place through the FBI system, through the Brady laws you all might have heard of, that are supposed to prohibit anybody who has a restraining order from accessing a gun. But those systems didn't work. The background check didn't work. He got a gun, and we know that he drove around with the children and with this gun all night. But the question of whether he killed them or whether the police killed them in the shootout, because as you see, there's many bullets that penetrated that truck, is still an open question to this day, which is the most pressing question for Jessica, is demanding those answers to how, when, and where those children died. This is just to underscore some of the stereotypes and misunderstandings of family violence. Below is a quote from the Chief of Police of Castle Rock, Tony Lane, saying on 60 Minutes, Jessica's case made headline news everywhere as it was going up to the U.S. Supreme Court. And Tony Lane says, well, what safer place could children be than with one of their parents, the mother or the father? Really misunderstanding the entire nature of the restraining order and domestic violence more generally. So let's take a look at the language of the restraining order on the one hand, and then the Supreme Court's, the key language from the Supreme Court's decision. So the language of the restraining order is that the police officer shall is the operative word here, use every reasonable means to enforce a restraining order, shall arrest or seek a warrant for the arrest of the restrained person if they have probable cause to believe the restraining order was violated. Well, in the majority opinion in town of Castle Rock, Justice Scalia writes that we do not believe that these provisions of Colorado law truly made enforcement of restraining orders mandatory. So shall doesn't mean must, he says, and he likens the statute, the Colorado mandatory arrest law, to other laws, other state laws that say, for example, the police shall arrest if they have probable cause to believe that a crowd poses a threat to public safety. And Justice Scalia says, well, the police need to have discretion in that type of case to determine whether that crowd poses a threat to public safety. And likewise here, the police need to have discretion in determining whether this person actually poses a threat. Justice Stevens, joined by Justice Ginsburg, wrote a blistering dissent that argued that that Justice Scalia's interpretation of the Colorado law eviscerated the very meaning of the mandatory arrest law, and that the legislative history was incredibly clear that the entire purpose of enacting this mandatory arrest law was exactly to counter the perspective that the police should have discretion. And Justices Breyer and Souter in the case, they gave a concurring opinion. That was kind of very confusing, frankly. So what happens after the Supreme Court's decision? A couple of things happened here. Domestic violence and women's rights advocates were outraged. This case really mobilized the women's rights, civil rights, domestic violence community. And I actually, hold on. I got involved in the case. I was at the ACLU at the time. I was a baby lawyer, just a couple years out of law school. Excuse me, I hope this doesn't affect me. And I was coordinating the amicus briefs before the Supreme Court. How many of you guys have heard of amicus briefs? Okay, excuse the throat lozenge. So amicus briefs are friend of the court briefs that are created and submitted to the court by organizations and individuals in support of a particular case that are not party to the case. So the domestic violence and women's rights advocates that coordinated to submit amicus briefs in this case, there were over 150. And so in this case then, Brian, could you do me a huge favor? Could you get me some hot water, like some tea from the clinic? I'm sorry. I'm just worried. This is one of those coughs that like you literally can't talk. Okay. So, thank you so much. So, this group of advocates from around the country was outraged, and they kind of mobilized together, saying, "Well, what can we do? We have a decision from the highest court in the land, and we're not. You know, does this mean it's the end of the line?" They thought that this decision sent a message that restraining orders don't need to be enforced. This fostered a culture of impunity for police officers who thought that they could act outside the bounds of the law. And very importantly for Jessica, it left her deprived of her day in court. This case went up to the Supreme Court on a motion to dismiss, which I think you guys probably have all taken Civ Pro by now, or most of you have. Motion to dismiss means you get no testimony, no trial, no evidentiary hearings, no discovery, right? And so this case went up on a legal question to the Supreme Court. and Jessica never got her day in court, so to speak. Jessica and her family were insistent that something must be done, and that we couldn't let it rest there, that the Supreme Court couldn't have the final word. They insisted that this dichotomy between U.S. law and international law, that I'll go over in a minute, could not, that they would not stand for it, and that they wanted to be, in many ways, the poster children for shining a light on this dichotomy. So let's take a look at that dichotomy for a minute. U.S. law U.S. law says, under this very famous case of DeShaney versus Winnebago County, that many of you might be familiar with, that there's no governmental duty to protect individuals from private acts of violence, even if there's a clear and preventable threat. There are a few exceptions if you're institutionalized or if the government has created the danger. It's called the state-created danger theory. But that's very hard to prove, and it's a very narrow carve-out. And this is a very tragic case. This is a case that some of you might have read with the famous dissent that starts, poor Joshua, right? This poor child who has, thank you so much, Brian, I really appreciate it. Thank you. This poor child in the DeShaney case his mother called Child Services repeatedly, asking that they not allow him to have access to his father. The parents were separated, and Child Services did nothing to stop the father from having contact with the child. And tragically, the father beat the child terribly, turned him into a vegetable. And those were the facts of the DeShaney case from 1989 that really formed the backdrop for the assertion that U.S. constitutional law does not provide what we call affirmative obligations of the state to protect individuals from private acts of violence. Well, let's look at international law, which finds that state responsibility ensues. And when we say state, by the way, we mean governmental, right? State in the international law sense of things. That governmental responsibility ensues when the government, any governmental entities, right, law enforcement, public housing authority, judicial officers, etc., knew or ought to have known of a real and immediate risk to an identified individual by another person, and number two, fails to take reasonable steps to prevent the harm. So that's this test that's been established under international law, a very well-established test. And do you see the way it's really, this is a bifurcated area of law where the U.S. standard is completely contrary to the international law standard, at least the U.S. constitutional standard. The human rights framework also offers, in addition to this focus on affirmative obligations, it also offers an alternative focus on things like the root causes of problems, right? Not providing a remedy to an individual only after the fact, but on addressing the root structural causes. The equality analysis in an international human rights framework focuses on disparate effects, not only discriminatory intent, which for those of you who have taken employment law, for example, this is a very well-developed area in employment law where, for example, one could sue for employment discrimination if an employer's actions have a disparate effect on a protected class of people. Not just if you, as a woman, minority, somebody affiliated with a particular religion, etc., fill in the blank, were discriminated against in a very direct way by your boss. I hate fill in the blank. But if your boss has policies and practices that end up disenfranchising certain segments of the workforce, well, likewise, that same standard, which is really only in narrowly cabined in certain areas of our domestic law. It is not ingrained in our equal protection law, for example, in the United States. So for those of you who have taken con law, you know that in order to prove discrimination under the 14th Amendment, you need to prove discriminatory intent, not disparate effect. Well, the human rights framework allows for this disparate effect consideration. Governmental accountability, again, looking at the role of government in creating or condoning human rights abuses. Dignity of victims and survivors, giving them this voice that I talked about. individual reparations, and structural change. All of those things are core components of the human rights framework. I want to shift for a moment to look at a place in which we're seeing really interesting developments in the US in the area of immigration law that really embraces these principles of international law. And I want to think about for a minute how it is that we're seeing immigration law incorporating these principles of affirmative obligations, and I'll tell you about that in a minute, and juxtapose that with our constitutional law regime, which does not recognize those protections. So very recently, the Board of Immigration Appeals, which is the highest court within the immigration law system here in the United States, found that a woman from Guatemala who had experienced severe domestic violence back home and had been unable to obtain protection from local law enforcement and her own government was eligible to apply for asylum in the United States, that she had a well-founded fear of persecution on the basis of her particular social group, right? The social group being married women in Guatemala who are unable to leave their relationship. Now, for those of you who have taken immigration law, you know that oftentimes social groups get defined very narrowly in the asylum law context. And this is how the Board of Immigration Appeals defined this social group. But what they really did was they widened up, they widened the category of individuals who are eligible to apply for asylum on the basis of being unable to access protection from domestic violence in their home countries. And it has tremendous implications, in particular in the contemporary context, when we see these huge influxes of people from Central America and Mexico coming over right now. And this has the potential to really slow the pace of deportations for women who could make an argument that that's the reason they're fleeing. I'm so sorry, I'm coughing into your ears with this microphone. So what does this ARG-CG case mean? And I commend it all to you. Look it up. It's really exciting. The New York Times did great coverage of it. It's been kind of very well covered in the media. And also that's a case that clinic students played a very key role in. This case recognizes the state responsibility to protect domestic violence victims. Importantly, it's other states' responsibility, right? It's other states that the United States is now granting asylum to people from those states because they were unable to access those protections. It counters doctrinally this U.S. constitutional standard regarding affirmative obligations, and it mirrors the international law standard that we talked about. Just because we see the development, though, in U.S. asylum law does not mean that maps onto the U.S. con law context. So let's shift back now to Jessica's case. So we have the Supreme Court decision. It's, like I said, folks are outraged. Jessica and her family are outraged. They want to do something. So we put our heads together. This was back in 2005. And we said, what can we do that can allow an international body to say that what happened was wrong? That's what Jessica wanted. She wanted some official body to say that what happened was wrong, and she wanted to be given a chance to have her day in court. And so we had a series of hearings before the Inter-American Commission. We filed this petition to the Inter-American Commission in 2005. Had a series of hearings. You saw one of them in the video. Jessica got 2 opportunities to testify before the Inter-American Commission on Human Rights. And then we got this amazing decision. Before I go into the decision, I want to just tell you a little bit about the commission, and I don't have a slide on this, unfortunately. The commission sits in Washington, D.C. It's one of the 2 organs of the Organization of American States that's focused on human rights protection in the Americas. And so in many other countries in the world, if you go to a law school, law students will be taking classes on the inter-American system as part of their regular law school education. It's a system that's widely used in other countries. Many countries, like Colombia, for example, have provisions within their constitution that state that international law has the same weight as domestic law. And the Colombian Constitutional Court, for example, and many other courts throughout the Americas will take decisions from the inter-American human rights system into account as they're deciding a particular case, just as they would be taking into account their own constitutional or statutory law in that country. In the United States, it's a growing area. The United States has not ratified nearly as many human rights treaties as many of these other countries, and so the United States is not subject to the jurisdiction of the American Court of Human Rights, which sits in San Jose, Costa Rica. The Inter-American Commission on Human Rights is kind of similar to the lower court. You might think of it like the Inter-American Commission is a lower court and the Inter-American Court is the higher court. That being said, the Commission is not a court. It is a tribunal that has a function to receive cases, what we call contentious cases against countries. And they do issue decisions that look a lot like judicial decisions, but they're not technically a legal tribunal. And what often happens in most of the other countries in the Americas that have ratified the American Convention on Human Rights, the advocates would bring a case to the Inter-American Commission, and if they succeed on that case and get a good decision from the Inter-American Commission, if the country does not comply with that decision, then usually the case goes up to the Inter-American Court of Human Rights, and then they issue a final binding judgment. So in this case, we in the United States and Canada too, and a couple other countries, Trinidad and Tobago, these countries have not ratified the American Convention, and so the Inter-American Commission is kind of the highest international body that we can go to bring individual complaints of human rights violations. It's really the only international body that we can go to that allows us to bring individual cases. There's other bodies within the United Nations, for example, that allow us to focus on larger kind of widespread patterns, but nothing that actually allows us to bring an individual case on behalf of an individual victim. And so this is a very unique forum. And it's very underutilized by U.S. advocates, oftentimes, and we'll talk about this more, because U.S. advocates are oftentimes asking the question, what does this actually get me? Where does this get me? If it's not a binding court, and if most people in the United States have never even heard of it, what is the value added? And we'll talk a little bit about that in a moment. So the Inter-American Commission issues this amazing decision, from my perspective, in 2011, finding the United States government responsible for violations of a document called the American Declaration on the Rights and Duties of Man. That's the human rights instrument that we're working with because it's the only human rights instrument in the Americas that's relevant to the United States, since the United States hasn't ratified most of the treaties. And let me just say one more thing about the Inter-American Commission, which is that in order to be able to take a case there, you have to do what's called exhaust domestic remedies. And that means that you need to have gone to the highest court in the land or the highest tribunal in the land at the domestic level. And if you don't achieve success there, then you can go to the international community. There's an exception to that if it would be futile to go. If you can show that your legal system is corrupt or your case law is such that you would never succeed, you can just circumvent that and go straight to the Inter-American Commission. Well, we had a case from the US Supreme Court. It was the perfect test case. And so that, in many ways, I think is why the Commission, the Inter-American Commission, took this case and really just put everything into it, because they saw the value of a case where you have fully exhausted domestic remedies, where you have a very compelling set of facts, and where you have a domestic law standard that is out of step with international law. So they find violations of the following articles. And one more thing I'll just say, because I know most of you haven't taken international law. The case is brought against the country, not against Castle Rock, Colorado, not against the state of Colorado. Once you exhaust domestic remedies and you go to the international sphere, it's against the country. Right, so that is how this case becomes versus United States, and the United States as a whole becomes responsible for this tragedy, for this violation. That doesn't mean it's only the federal government, but under international law, it means all of the entities that make up the United States, municipal, state, and federal, are all jointly responsible, and it's up to the country to figure out how to put this decision into place. But nevertheless, everybody has joint responsibility as United States. So the rights to life and personal security of the girls are found to be violated. Equal protection and non-discrimination. Again, this principle that domestic violence disproportionately impacts women and girls, and thus there's an equal protection violation in that the Jessica's tragedy is symbolic of the tragedies of so many other women and girls experiencing domestic violence and getting kind of a backhand slap from the police department. Special protections for children are codified in international law, and due process and judicial protection, since she was denied any sort of kind of a fair process, and the police did not inform her of their decisions. So that's the official decision from the Inter-American Commission. I just want to highlight a couple of the key places. This is a 60-something page decision, I believe, so very kind of long, well-developed, and they really do a beautiful job of, and I commend it to you. If any of you are interested in reading this further, it's available online. They talk about this concept of due diligence. How many of you have heard of due diligence outside of the context of corporate law? Okay, nobody, right? When I think of due diligence, I think of, well, I don't, but I, as a member of the lay public, would think maybe, corporations, corporate law, right? Well, due diligence in the international human rights context has these 5 prongs: prevent, investigate, sanction, and offer reparations. Really, I've listed it as 4 prongs. It's listed as 4 prongs here, but it's oftentimes listed as prevention, protection, investigation, prosecution, and offering reparations or remedies. And they make clear this applies. The state has to exercise due diligence even when you're talking about acts by private actors. It's not just if a state actor, if a law enforcement officer beats you up, it's if a law enforcement officer fails to protect you from a private individual who does. And they talk about this discrimination and intersectionality. This language of intersectionality is a movement within critical legal studies, which some of you might learn about in law school, which finds that women and different groups and different individuals will experience discrimination on multiple axes of their identity. That if you are, for example, a Native American and Latina woman like Jessica Lenahan, you might experience domestic violence and state response to it in quite a different way than a white upper middle class woman might. And in this case, Jessica lived in a largely white upper middle class town, and she was, her last name was Gonzalez. She's Latina and Native American, lower class. She was actually a janitor at one point in the Castle Rock police station. So the perceptions of class and race and gender all kind of conflate together, the commission says, and might have an aggregate effect when we think of a discrimination framework. Eliminating prejudice and stereotypes. The commission says that states have to take measures to modify the social and cultural patterns of conduct and eliminate prejudices and stereotypes, right? This idea of kind of wholesale cultural change, like Jessica talked about in the video. And so the commission always issues recommendations at the end of their decisions, and they issue 3 individual remedies and 4 policy or structural remedies. The 3 individuals are that there's got to be an investigation into Jessica's children's deaths and into the systemic policing failures that happened that night, and that there's got to be remedies paid to her, reparations rather. In terms of the policy remedies, the commission really hones in on the importance of enforcement of restraining orders. And so they say that there's got to be policy measures taken to ensure that restraining orders are enforced and that children are protected from domestic violence, and that we eliminate stereotypes in our response to domestic violence survivors. Okay, so now we're at the why bother section, right? Of like, this all sounds great, but where are we going with this? How is this useful for actually advancing the advocacy, changing law and policy, seeking justice for Jessica? So now I'm going to kind of give you a couple of 5 different ways in which I think kind of globally international human rights advocacy can be useful for individuals and groups who are seeking justice who have hit brick walls within the U.S. justice system. And then we'll take a look at a couple movement building. Like I said, the groups that, we have till 1:30, right? 1:20, okay. So all of these groups kind of mobilizing together. Thinking about alternative policy frameworks for incorporating these concepts, right? Ways in which we might get these international concepts to seep into our domestic law, and I'll talk to you in a moment about ways we're actually seeing that happen. Naming and shaming, how we might kind of use this to exert political pressure, and then influencing public opinion, changing the way we talk about these things. So we've got local domestic violence and human rights resolutions that have now cropped up in, I think, 13 or 14 different municipalities that are all listed here. This was a movement that came after Jessica's decision, where advocates across the country thought, let's think about ways to incorporate the principle that freedom from domestic violence is a human right and incorporate it at the local level. Let's bring it home. And actually, we just had great success here in Chicago just a couple weeks ago, and this is on the clinic's webpage. The Chicago City Council just incorporated the latest of the resolutions. And so one of the things our clinic is going to be doing in the next couple months is thinking about ways to implement that. These resolutions say, freedom from domestic violence is a fundamental human right, and this resolution shall serve as a charge to local agencies to incorporate the principle into their policies and practices. So I'll just give you, and then we just got a presidential proclamation, actually two, that say largely the same language. So at the very end, you see that the presidential proclamation reaffirms the basic human right to be free from violence and abuse. We've been really working with the president's office to push them to get this language incorporated into a proclamation because, like everything else, proclamations and resolutions, they don't do anything on their own, but they are statements of the executive that can then be used to influence policy. So you see the way this is about very small incremental change. And so much of this work, whether it's called human rights or social justice or civil rights more broadly, has to happen over a period of decades, if not centuries. And so we're not going to see any large-scale sweeping changes overnight, but we're seeing these kind of incremental changes in the way our government is talking about domestic violence, which is a huge landslide if you look at kind of the language from 5 or 10 years ago. So that's a really exciting development. In Miami-Dade County, my clinic, we worked on a resolution there, and just I think that next week, an ordinance is about to be passed that cites to the resolution and that prohibits discrimination in employment, family leave, public accommodations, housing on the basis of all of the protected classes, race, gender, etc., and adds domestic violence victim status to that list. And this, again, has come out of the resolution. These are initiatives, legislative initiatives, ordinances that are now taking shape that can serve that role. And when we have the Q&A, I can talk to you about some other ideas. Another place that we're seeing some shifts in the way our government is going about things is that the DOJ is conducting investigations into law enforcement response to domestic violence and sexual assault for the first time. These started in 2011, right around the time of the decision in the Lenahan case. And we were privately told by many people that the Lenahan case really pushed people from within DOJ to re-examine how they think about inappropriate law enforcement conduct, and made them realize, oh wow, we never really thought about gender bias in policing. And so that's an area that we've really been developing. We're hoping, and we being kind of a coalition of domestic violence and women's rights advocates are working with the Department of Justice to try to get them to adopt actual guidance that would incorporate some of these principles of gender-biased policing. The vice president, very excitingly, I was in DC for a just last month, actually. Feels like a year ago, but I was there for this announcement or for a celebration of the 20th anniversary of VAWA, the Violence Against Women Act, which you guys probably most of you are familiar with. And the vice president is standing there in the National Archive in this very, elegant ceremony, and he announces that he's convening a summit on civil rights and equal protection for women, and that he wants to reinstate the civil rights remedy that was struck down in the Morrison case. If you're not familiar, look up Morrison versus United States, and you'll see that a very important piece of the original Violence Against Women Act, which allowed a victim to sue her attacker or abuser, was struck down by the Supreme Court because the Supreme Court found that violence against women does not constitute interstate commerce. And Biden wants to reinstate that provision. And so one of the things that several advocates are doing are trying to make strong suggestions to the vice president's staff that when they do reinstate that they should allow for not only a provision for a victim to sue the attacker, but also for a legislative provision that would allow a victim to sue law enforcement for failing to respond appropriately. That would be a Castle Rock fix. So again, you see the way little by little we're building this. I also just wanted to talk about the international impact of the case. Advocates across the world have been looking to the Jessica Lenihan case for inspiration and guidance, and the Constitutional Court in Kenya just cited to it in a case involving the police failure to respond to acts of rape against young girls in Kenya. It's a widespread problem. The Constitutional Court cited to the Inter-American Commission's Lenihan decision in finding that the police had a duty to respond. What about Jessica, though? Where does she fall in all of this? That is kind of the overwhelming question. We've started to see kind of these really interesting incremental changes with respect to kind of large-scale structural problems. But what about the individual in all of this, right? Wasn't she the one who wanted to have somebody say that what happened to her was wrong in the first place? And what obligation do we owe to her as our client? This is a very important question for you all to think about. Anybody who's interested in social justice advocacy, civil rights litigation, human rights advocacy, these are very important questions to think about how we use individuals as poster children for larger causes and how we work with them, what's our obligation to the client versus the cause. These are important ethical questions as well as strategic questions. So justice for Jessica has been in some ways the hardest uphill battle because nobody in government, be it federal, state, or local, wants to question the Supreme Court's decision. Case closed, they say. She had her day in court, so to speak, and she lost. So what we've been trying to do is work with a local senator in Colorado, and we got this recent tribute to Jessica from the state Senate in Colorado that says that her domestic violence incident remains unresolved, and it's a tribute to her and talks about her determined crusade, validated by the Inter-American Commission on Human Rights. It has reaffirmed the fact that freedom from domestic violence is a basic human right. Again, that's the language of the resolutions. So we've got this amazing now tribute to her. We've got a state senator who's on board in Colorado. And, well, because we're low on time, I'm not going to show you. If you're interested, this is available. The state senator reading her the tribute is available online. And it's a pretty moving piece of video to see. So this is the end of the presentation. Challenges ahead. Implementation of all of this. How do we implement this? And once we get the resolution, once we get the legislation, there's always a next step in implementation. How do you notify the public? How do you get people on board? How do you get governmental agencies and officials to know that this is the law? The same problems that we have with the very mandatory arrest law that's the subject of this case. In many ways, this is the reincarnation of the question of what does it even mean to have a law on the books? And how do we get governmental officials to respect that law and adhere to to its purpose and principles. So we are working on all of those questions, both, again, kind of, as I say, on the meta level, the structural level, and on the individual level. And it just so happens, this is kind of coincidental timing, we have a big hearing in the case on Monday. And our clinic students will be participating in that hearing as well. And it's going to be live webcast, so if any of you are interested, it'll also be available, preserved on video. But CIDH.org, that's the Commission's website. It's in English, Spanish, French, and Portuguese. So if it brings you to the Spanish one, which it defaults to, don't worry, just click on the little either American flag up top, and it'll bring you to English. And you can watch the actual hearing, either live or after the fact. And I'd love to hear from all of you, right now and then after the hearing about your impressions and thoughts on where we go from here. So thank you. Questions, thoughts?
When you put up a slide about the responsibility to protect both comparing the United States standard to international standard, this international standard is coming from what? From case law?
From case law.
Not treaties?
Not treaties, although it's the interpretation of the treaties that's been established in case law and through other forms of law, which we might call soft law, different international human rights bodies that have interpreted those treaties. Other thoughts, questions? Yeah.
You mentioned that the UN is not a remedy for bringing her case. I'm wondering if you could go a little bit more into why the UN is not an appropriate place to bring something like this.
So the UN treaty monitoring bodies, of which there are many, each of which is responsible for monitoring state compliance, country compliance with a particular treaty. So there's the UN Human Rights Committee, which monitors countries' compliance with the International Covenant on Civil and Political Rights. There's the Children's Rights Committee that monitors countries' compliance with the Children's Rights Convention. There's the CEDAW Committee that monitors countries' compliance with the Women's Rights Convention on the elimination of discrimination against women. Okay, so you have kind of these corresponding bodies and the treaties that they're supposed to monitor. There's a couple things that you need to know when you think about the role of those bodies and the treaties. The first is that those countries can only monitor countries' compliance with the treaties if the country has ratified the treaty. So the United States has only ratified 3 of the UN human rights treaties: the Torture Convention, the Race Discrimination Convention, and the Convention on Civil and Political Rights. So that means that those 3 bodies can analyze and consider how the U.S. is complying with those treaties. However, there's a catch. The countries, in order to submit themselves to those human rights bodies, for individual case considerations, they have to sign another treaty. And those are called optional protocols to the original treaties, and that allows an individual to bring a case against the country before that body. So if a country has signed both the treaty and the optional protocol, then a victim of a violation by some entity within that country can bring an individual case to the body, but then they can also have their case considered as part of a more general consideration, an overall consideration of the country's human rights record with respect to that treaty. And so right now in the United States, we've brought Jessica's case to those 3 UN bodies because in order to have the UN bodies consider her case as part of the larger problem of governmental response to domestic violence. But when when those human rights bodies issue, it's called concluding observations, when they issue these concluding observations, they will never name an individual person or an individual case. It will be more about a systemic problem. Yeah?
Yeah, you mentioned Colorado having mandatory arrest laws as far as people with domestic violence type restraining orders, and I'm wondering if that was a pretty clear violation of that. Has there been any investigation into that, or is that something that's also being looked into?
Well, it's a good question because the Supreme Court's decision basically says you don't have a constitutional claim. whether the police violated that, that statute, they say that's an issue for the state court to decide. And so they suggest kicking it back to state court. The problem with that is that state laws in Colorado, tort laws, for example, that would allow you to sue the police for negligence, have a very high threshold for overcoming immunity. And so in order to prove that the police were negligent, you'd have to show that they acted willfully and wantonly, which essentially amounts to intent. And that means you would have to show that the police intended for the girls to die. So as a result of all of that, you have no constitutional remedy, and you really have no state tort remedy. So Jessica was left, with no remedies available to her.
So I'm wondering, a lot of these issues seem to be addressed in terms of how to deal with the domestic violence after it's already happened. But to what extent is international law and U.S. law addressing it for prevention? And sort of ideally, we want these domestic violence cases to not occur in the first place.
Mm-hmm. So that's really important, and that is part of our work on the guidance, the DOJ guidance that I talked about, is trying to get guidance in place, again, for education of law enforcement. And we hope that that will actually lead to increased trainings of law enforcement. Training isn't everything, and training can be very controversial because many people can kind of criticize it for being something that doesn't have teeth to it. But in Colorado and in many places, law enforcement in Colorado are only required to have 8 hours of domestic violence training throughout the course of their career, and almost all of that happens in basic training when you first become a law enforcement officer. And just think about that from our perspective as lawyers. We have to go to CLEs, continuing legal education. You guys will learn about that. You have to go to CLEs every year in order to keep up your legal education, and it's a pretty arduous requirement in order to maintain your certification with the bar. How is it that domestic violence, which many law enforcement agencies say occupies the largest number of calls? New York City Police Department gets over 200,000 domestic violence calls a year. How is it that law enforcement officers are getting such little training for something that occupies so much of their time? It just doesn't seem, from a basic professionalism perspective, that they're being adequately trained. So that's the type of thing that we are working on. But one of the questions that you guys will consider in your law classes, from here to eternity, is whether putting a right of action in place that allows for a lawsuit can contribute to changes in the way in which we behave. I think maybe we have time for one more question, and then we're going to break. I saw a hand up over here. Did you have?
Oh yeah, so given that the court struck down the VAWA tort remedy in Morrison, what would be the avenue for getting that remedy like was struck down as a violation of the Commerce Clause? You said the Vice President said he wants that back in place. How would that be done? So
you would need to build the legislative history on why violence against women constitutes a form of interstate commerce, and so you'd need to show under Commerce Clause analysis how that affects interstate commerce, and you'd need to do it better than they did it the first time, and they did it pretty darn well the first time. So there are challenges ahead. You also have a different Supreme Court this time around, for better or for worse, and so you may have different opportunities or challenges ahead in the inevitable constitutional challenge. Well, thanks everybody, and thanks for putting up with my voice.